Good morning. Please take your seats. We start our panel on archives and data protection. And this topic has been missing from the menu, the intellectual menu card of this conference for so long. And I think we start now a channel, or at least a group of presentations, not during this conference, but in the future. And I think that most of you who are in this room have some idea about what data protection is. But I would like to talk a little bit about archives. By the way, who are from the archival field in one sense or another? Yes? One? Only one. OK, very brave. Thank you. So you can check what we are talking about is correct or not. So the schedule is, my name is Ivan Székely. I will be the moderator of this session. I'm a senior research fellow at the Blinken OSA, the Open Society Archives at Central European University. And I think at this point it's enough. And about the archives. Archives, as we all know, are memory institutions or memory-preserving institutions, together with museums or libraries, but also there are some others like public cemeteries. They're also memory institutions, or memorial parks or other kinds of memory institutions. I recently heard about an archive of historical smells. Maybe you could call it a museum, but no, it's an archive of historical smells. Archives collect documents, or in the US terminology, records. My conviction is that documents is a broader term than records, because a few years from now, when it will be very famous, this first archives and data protection panel at the history of CPDP, maybe it will be a document in an archive, but it's not a record. It doesn't have a date of creation. My name is not on it. Maybe you can identify me because it's handwritten. So documents. But the access to documents and restriction of access is based on data or recorded information in the documents. Even if the stamp is on the document, on the paper, or it's in the digital domain, it's somehow indicated, but the essence is the information, the data itself. And in the past, archives collected historical documents and data within the documents, and within the sphere of data, of course, personal data. But nowadays, archives collect more and more recent documents. And this is one branch of the problems what archives and archivists must face. The other branch of problems is the technological developments. There are a lot of digital documents, born digital or digitized documents. There's the internet, there's the artificial intelligence, one of the central topics of this conference. And by the use of these new technologies, it's possible, for example, to re-identify formerly anonymized data, if you combine that, and so on. You know all these. And this is the environment in which archivists, researchers, users, regulators try to find solutions. And this is the environment in which our panel will discuss all the problems and possible solutions. The composition of the panel is very fortunate, because we have experts in law, in technology, in archival science, in digital humanities, in your case. So I'm absolutely convinced that we will have an interesting panel and an interesting discussion with your contribution from the audience. I would like to introduce the first speaker, who is Michael Friedewald, who is senior researcher and head of the ICT research unit at the Fraunhofer Institute for Systems and Innovation Research. But otherwise, he is the organizer of this panel, convener of this panel, so he has a double function or triple function. The focus of his work is on the social and economic impact of emerging technologies and their implications for policy making. He was coordinator of several FP7 projects, such as the Preston, the Sapien, the PRISMs, and all dealing with some privacy aspect of new technologies and surveillance systems. So the floor is yours, Michael.
Yeah, thank you, Ivan. Apart from all these European projects you mentioned, I will present today some insights from a study that we recently did.
Can we have
the clicker? Clicker?
And this is the clicker.
Yep. Okay.
Wait until it... No, it's not.
No. Okay. Today I will give you some insights into a study that we did earlier last year on behalf of the Council of Europe on the implementation of a recommendation that was adopted almost 25 years ago. May I ask who is familiar with the institution of a recommendation by the Council of Europe? Well, some of you, yeah, that's good. In the late 90s, the Council of Europe, as the institution keeping track of human rights in Europe, has adopted a recommendation in response to the opening of archives in the aftermath of the transformations in Eastern Europe. So there was a demand to have access to all these documents of the secret archives, and the Council of Europe responded to that. And maybe just one point, they formulated the right that access to archives is a right. This is maybe the cornerstone of this recommendation, and there are a couple of subtopics that detail this right. The recommendation is not legally binding, but has had some leading function for policymakers over a couple of years. Apart from the fact that there is a right to access to archives, the Council of Europe has also recognized that there are exceptions for that, and that they are quite familiar for those of us who deal with data protection or the AI Act. So, for instance, public interests such as national security, foreign relations, stuff like that, are a reason to exempt documents from being accessible. And of course, one of those is the protection of individuals, which means data protection issues. Snag is the recommendation has been adopted in 2000, which is, well, hundreds of years ago in terms of digital technology. So it was long before the GDPR and long before the internet had some really meaningful impact. So it was time to have a fresh view on to what extent this recommendation is implemented and what new problems may have come up. Yeah, we did that with a survey among public archives in Europe, mainly the national ones. We had an online survey among 48 of these archives, and we got quite a good response. And to make the long story short about these implementation issues, the general observation is the recommendation had its leading function, and most of the national legal frameworks in Europe are compliant more or less with the recommendation. But a little bit surprisingly, we were faced with some complaints that at the moment there is some uncertainty or unevenness with data protection, so that many of the archives say, well, we do not really know, there is a problem caused by the GDPR, because there is obviously a clash of interest. This slide may exemplify that, because The recommendation says that documents that have been transferred to the archives shall be made immediately accessible to the public, or, which is in most of the cases the case, that there should be a unified, harmonized closure period, which is in most of the archives 30 years. So far, so good. But obviously, this is not really in line with what we have, what we think about when it comes to data protection, because data protection doesn't know closure periods. And if you look to the chart on the right, there are of course restrictions due to data protections, and they do come from the recommendation itself, but they also come from the GDPR and other lex specialis. Think about birth records being in archives, stuff like that. And not very much surprisingly, we asked also what were the reasons why the archives denied the access to documents within a 12-month period, and data protection is one of the most frequently named reason for that, apart from others. So, what's the problem? We have national legal frameworks. As I said, the recommendation is not binding. The GDPR is binding in all the EU member states, but not in all Council of Europe countries. So there might be, and there are, inconsistencies in the national implementation of data protection procedures. And even more when you come to the ground, archival regulation is a national stuff, and each of the archive is having its own regulations for their users, which might differ, though it shouldn't. And in the end, there is legal uncertainty about which of the interests should prevail. Is it the freedom of information? Give out the documents to the people who request them? Or are you on the safe side if you say, well, the documents contain personal data and we prefer not to give out documents because we do not know? That's the second point. Data protection authorities obviously have the same kind of uncertainty. They act in quite a different way, some more defensively, some more offensively. And in the end, we heard things like, we are on the safe side if we do not give out documents originating after 1945, which is, of course, we heard some stuff like that, which is, of course, ridiculous if you think about the function of an archive. Finally, there is a delicate balance that has emerged over time. Because data protection also existed before the GDPR. And many of the archives said, well, we leave it to the responsibility of the researchers to make responsible use of the documents they get from the archives. So the archives not being the controller that no personal data is deployed in an uneven way, in an unjustifiable way, but to say, well, we rely on your responsibility as a researcher to do that in a meaningful way. Okay, so much to the problem that we came across with the survey of the archives. And a little bit of artificial intelligence is part of this panel as well, because we discussed what are the implications of upcoming AI tools in the field of archives, and as often there is shadow and light. There is, of course, and that has been discussed already during the last 1.5 days, the risk of re-identification of individuals in documents, even if names are not mentioned. And the recommendation and the archival rules in many cases foresee so-called partial access, which means that that sensible information, including personal data, is removed from the documents. And if you, well, apply AI tools, that there is the risk that this is undermining this tradition of making sensible documents accessible in this sanitized or anonymized way. But on the other hand, of course, AI also poses some opportunities, such as automated content sanitization. It's often said that that AI is repeating the biases within the data. In this case, this is really an opportunity, because identifying the bias by the documents and saying, well, this is a sensible information, not only from a data protection point of view, but it could also be that content is racist or being propaganda, stuff like that, which offers new opportunities to classify documents and make them accessible to the public in a at least semi-automatic, automated way. However, as usual, there is, of course, a need for the governance mechanisms and the rules if they are updated. So the Council of Europe, for instance, is considering to update the recommendation that they take care that there is good balance between data protection laws on the one hand and the ethical standards, and on the other hand, the aim to make data freely accessible to the public have a good balance. And if you're interested, the well, no. Good. Okay. There should be a picture of that document on that slide. It has been made public by the Council of Europe, I think last week. And if you Google for the title, you can find a PDF of the document freely available. Thank you. Can you repeat the title once more? Access to Archives in the Digital Age.
Okay, thank you, Michael. Take a seat. Who thinks that data protection rules and practices are a disproportionate burden on archives nowadays? Please raise your hands. One, certainly. Two. Okay, thank you. Our archivist colleague doesn't think like that. Okay, and who thinks that data protection rules and practices are unable to fully protect the data subject whose life is included in the documents in the archives? So unable to protect? Yes?
Unable.
Unable. So it's not suitable, the present regulation and practice in archives to protect the people in the documents. Okay? Certainly more. And who thinks that the present situation is just adequately handles the questions, so there's no problem in this field? Who thinks it is the case? Nobody. So we are quite critical. Many of you abstained. I can imagine these are very oversimplified questions. Any immediate reactions from the panelists? Short reactions before there will be a questions and answer Q&A session at the end of this panel discussion. But now, if you have, but I'm asking only the panelists. If you have
can I just ask a question about your definition of archives? Because you mentioned historical collections. So are you looking mostly at historical collections, or is it a wider definition of archives?
For the study, the definition was rather to the classical institutions, not so much to the post-custodial and private archives that we might discuss later.
Yes, as you may know, that the recommendation says that If you write archives with uppercase A, it means the archival institutions. And if you write it with lowercase a, that means the totality of the documents in the custody of an uppercase archive. So it's not always easy to distinguish, but the study, the survey, was directed towards uppercase archival institutions and public institutions, so private archives were left out, or church archives. So that's a certain range of subject. So now I turn to Louisa, and your short biographical note was really very short, so I will read it quite quickly. Louisa Palla is the head of the, yes, thank you, is the head of the Governance and Internal Compliance Unit at the European Data Protection Supervisor, the EDPS, as we know it. Prior to joining the EDPS in late 2010, she worked at the Historical Archives of the European Commission. So she has a kind of archival knowledge and history, so you are not a newcomer in this field at all. So Louisa, the floor is yours.
Thank you, Ivan, and good morning, everyone. Again, a question that was asked at the beginning of the panel: who has background in archives? As we had several new colleagues coming.
No, two.
And who is familiar with somehow the organization of EU institutions? That is my own background. So maybe I'll start actually with my last slide, if you allow me, because I'm very happy to be in this panel as someone who worked as an archivist before and now is in charge of internal compliance, organizational compliance with data protection. I have the data protection officer of our authority in my unit, and I have the records manager of our authority in my unit. And so the discussions, not much on archives per se, but on the preparation of what will go to the archives, are quite lively, and so my keen interest on this topic. Why I'm going to start with these few words. EU institutions, bodies, and agencies are subject to the EU DPR, so an adapted regulation that maintains the principles and obligations of the GDPR, adapting them to the context of the particular context of EU institutions and bodies. And this regulation, like the GDPR, has a specific article on archiving in the public interest, and then coupled with historical and scientific research and statistical purposes. Likewise, institutions are subject to archival rules in a bit peculiar way, in a sense. There is a regulation that imposes the establishment of historical archives for the institutions and their opening to the public after 30 years. After this period, the archives have to be transferred, the opened archives have to be transferred to the historical archives of the European Union in Florence. This is an historical arrangement that was made, enabling the EU Institute in Florence to be a hub for the history of European integration. This particular regulation was amended over time, once to comply with provisions that the EU institutions had on access to documents, and the second, and with the initial provisions on data protection, and the second time to reflect more the roles and responsibilities between the archives in the institutions and the central archives in Florence with regard to processing of personal data. In this second review, one of the provisions also requires the establishment of internal policies with regard to what personal data will be transferred, what will be the safeguards for their processing, and what will be the safeguards for their opening to the public. This work is ongoing at different stages of maturity in the institutions, but this, and particularly the 30 years rule, is the context in which we are operating in this year 20 years institution to prepare our holdings for for future transfer, knowing that our holdings are mostly electronic and that in addition to the traditional worries that archivists have on preparing a transfer to the archives, we have the format and support issues that add to that. But I will leave those worries for other working days. So I would go, oops. I wanted to briefly recall the specific provisions of the GDPR and the EU DPR on archives, because contrary to previous data protection regulation, archiving in the public interest is specifically given an article, not only an article, but is present in several provisions of the law. And the provision of the law allow for specific conditions in the processing, allow for exemptions from certain obligations under caveats and other circumstances, and allow for derogations to some data subject rights. As to principles in particularly, archiving in public interest and for historical, scientific research and statistical purposes, and already the time it takes to say this, I think, shows that these sectors are so different, though being put together in one article, that this may indeed contribute also to some, I think, intended flexibility and then on-the-ground fragmentation with regard to implementation of data protection rules. Further processing is not incompatible with the purpose for which the personal data were collected, and longer storage is permitted when it comes to archiving. So with regard to the principles, it is acknowledged that archiving in the public interest serves values and serves the society in preserving memory for future use, for accountability and future use. At the same time, the GDPR puts a strong emphasis and impact on data protection rights and data subject rights. In this case as well, the regulation provides for derogations to the rights of data subjects, but frames them so that a number of derogations are possible if enacted by law, and member states' law may have implemented derogations in different ways because of national legal requirements or circumstances. I want to mention two in particular: the right to rectification and erasure, and the right to information. So, as to the right to rectification and erasure, a derogation is permitted in that it is understood that rectifying records in archives, whereby the regulation identifies archives in line with what you mentioned, Michael. So institutions, private or public, mandated by law to preserve records of enduring value. And so it's clear that if the legal mandate is to preserve records of enduring value, rectifying those records, erasing those records, is not permitting to fulfill the purpose and is disproportionate. Likewise, for the right of data subject to be informed about processing operation on their personal data, the law provides for derogations in that for any potential personal data in archives, it may well prove disproportionate to satisfy to the information requirement, or may even hamper the fulfillment of the purposes. The fact that there are specific clauses on the principles and specific derogations on data subject rights comes in the context of safeguards both in the GDPR and EU DPR, the specific legal provisions for archiving in the public interest have in their title safeguards. So the focus is on how the personal data contained in the records are processed. And those safeguards can be technical or organizational measures. And so we've heard about what technology can or is exploring for. But they have to start with the data minimization principle. Now, the data minimization principle states that data have to be processed only if they are strictly necessary for a processing. Ouch, ouch. Thank you. No apologies needed. So then I'll go very quickly, and my apologies for that, for taking too long on this slide. Final element that I wanted to flag is that the regulation provides also for allowing the processing of special categories of data in the context of archiving in the public interest, provided that suitable and appropriate measures are in place to protect rights and freedoms of the data subject, given the particular sensitivity of those data. You mentioned balance. Balance for archivists starts way before access. Balance for archivists starts with being able to ingest those records of enduring value that need to be preserved. And why is that? Because lack of awareness or misunderstandings in the perception of the law or in the application of the law, and oftentimes channel work that is parallel but is never convergent, makes it that even when there is a clear legal framework providing for transferring information to and records to archives, the safest approach that Michael mentioned is sometimes preferred, and so the result may be that archivists have actually to struggle for their records more than they would do. And with regard to access and dissemination, this is in what you were flagging before, the core of the issue, but again needs to be distinguished in a way. National law and our own specific context have a closure period for records. This closure period is meant to be a safeguard, was meant before the GDPR to be a safeguard. And after that closure period, records and documents in archives are open for public access. But being open for public access and then being further disseminated, and I think in particular about online and mass digitization of archives, are two separate things. And in this, in assessing what are the risks and the impacts to data subject of mass digitization, of mass processing of personal data, lies the core of the issue that we are discussing today. But this risk assessment and the consequent obligation and measures, or need to take specific measures when protecting personal data in archival holdings, can only be done in context. You mentioned specific situations in member states. You mentioned different closure periods for different archival series that were created in specific historical context and have personal data that may belong to categories, to typologies of personal data that deserve more protection. This balance can only be achieved when there is a shared understanding of, on one hand, legal requirements, but on the other also potential harm, potential risks to which, even after passing a certain time, data subjects remain exposed. And I finished my So I'll finish with one.
Apologies
sentence.
again. We will have time after
then
the,
I'll keep
and
my-
you can
I'll keep my
develop
remarks.
further your thoughts. So thank you very much. Let me add some points to what you just mentioned. Balancing. I think Alexander will talk about this. Balancing is not always the right expression because it means that you give up something on one side in order to protect another right. And if the rights are fundamental rights, you need to find a solution that both fundamental rights are prevailing. Maybe it's easier to say that to do in practice. So that's one thing. The other is rectification. You talked about rectification. And in my opinion, I'm not an archivist, but I'm working in an archival institution. First of all, archivists are always working in a gray zone. Believe me, if you are an archivist, you can say it's not true, but and in the case of personal data, personal data is any kind of data related to a living person, to make it short. And but the archivist has no time and energy to investigate each and every case, whether the person is still alive or not, especially recent history archives. The other one, the rectification. Some archives are responsible for the content, for the truth content of their holdings, because people can go there then and ask for a kind of acknowledgement or any kind of official paper about their past or their personal data. Other archives, the historical archive, you can see that all archives are historical because they deal with the past in any sense, but there are historical archives which are not responsible for the content. What they're responsible for is the integrity of the documents. If those data are false, erroneous, for any reason, they must keep it as it is. Maybe if the data subject complains, then they can add a note that it's debated, but otherwise the original document should be dead. And if I could read my own notes, that would make it longer than, what is it? Okay, that will be a secret, and we won't have access to this secret information. But at the general level, the rules are clear, I must say, but the devil is always in the details, as we know, and in the practice of archives. The one extent you already mentioned, both of you mentioned that it's the easy way is to close everything because let's be on the safe side. Or to open everything and push the responsibility to the researcher. That's also unfair sometimes. Because if the researcher, we don't speak about scientific researchers as such, but private persons, journalists, so it's unfair to put the responsibility for them, whose task is to publicize everything. Okay, I stop here, and I give the floor to Alexander, briefly introducing himself. He's a human rights lawyer. He's executive director of the Access to Information program in Bulgaria, well-known civil organization having a long history. I hope many of you know the organization and maybe Alexander himself. He has provided legal advice and litigated hundreds of access to information, freedom of expression, personal data protection, and other human rights cases before national and international tribunals, including the European Courts of Human Rights. He also trained thousands of civil servants, lawyers, NGO representatives, judges, and journalists in the region. That means Bulgaria and in the neighboring countries, in the former, let's say, Soviet satellite countries. And he's also author and co-author of 6 books on access to information litigation and many chapters in other books. The floor is yours, Alexander.
Thank you very much, Ivan. Hello, everyone. I'm very happy to take part in this very interesting session. But we don't have much time, so we already have some important questions being posed. I will briefly talk about some cases with the state archives in Bulgaria and the balance with personal data and balance. I agree with Ivan. It is very important that balance could be sacrificing one right for the other, or it could be even sacrificing for a long time one right in place of the other. But it could be also, and basically it should be made on case-by-case level, according to the European Court of Human Rights and national courts in Europe, which means that even if a right is sacrificed, this is not for forever. But in one case, this is this manner, and in another case, it's another manner. Then I'm going to talk about the former state security services and some two issues that are not directly connected with archives, but are somehow connected. Courts and archives, because court documents are very often in the archives and they're of high public interest, and journalists, journalistic archives, but also journalists, because here the question of whether a document, if the data subject would like to rectify in the archives, you have a lot of solutions in the media sphere about that. Because, for example, in journalistic expression, which is another derogation under GDPR and the 95 directive beforehand, journalists usually don't delete data if they believe that they're fine, that they're true. But they can always, and they should always, under the ethical standards, add a note that someone responded and wants his or her opinion or position to be somehow presented. And this is something that the media decides how. Yeah, very briefly, we don't have many cases of requests to the archives which were not served. Before, the archives were for a long time in Bulgaria very traditional, so to say, paper fold, paper oriented. There was an interesting case a few years ago where some media, especially TV stations, wanted to get access to registers of soldiers who died during the Balkan Wars, which is right before the First World War. And the state archives were a bit reserved to provide this extra information because they said it's on paper, but it's registers. And because of the big publicity, this was one of the American TVs, because Tom Hanks have found some relation with Bulgaria in his past. So this was mainly one of the ideas. But these were much more challenging. The digitalization of archives. Some years ago, the archives, the state archives in Bulgaria started projects to proactively publish. And here you have much more questions when it's proactively on the internet. At least two data sets where they consulted me. One was the so-called People's Court in communist countries. I don't know about the others, but in Bulgaria we had this People's Court, which were designed primarily to crush the political enemies. So there were not fair trial in these courts and so on. And one of the issues was to publish all the documents from this People's Court, which means the indictment, the records of the hearings. And people in the archives were thinking that having so many names, some of whom alive and so on, could bring problems. And another data set was the data set of the political party decisions, because the political party, which was the only ruling party, but it did not only occupy all the state bodies, but it also had its own bodies, which were very influential. So they could decide things for the public. So they wanted to publish all these decisions of this committee, political party committee. So in the beginning, they were thinking that it's a problem to publish the court's documents, and it's not a big problem to publish the decisions of the political party committee. Well, I told them that all the documents should be inspected by a human. And here is one of the questions about the artificial intelligence and human. Well, if we talk about court records, for example, in Bulgaria we have two level standard. First, to have the automation, the work done by machine, and second, a human comes after that. Here, I've expected some of the documents, and because I wanted to tell the officers, the servants, how to deal the job. What is the approach? Surprisingly, in the sessions of the People's Court, I didn't see any really sensitive information, sensitive data. So there were not ID numbers at that time, of course, yet there were not intimate things or some things that can identify really a physical person too much, so everything was public. So this bigger fear of the people in the archives was not legitimate in the end. But in the party decisions documents, we found a lot of, well, they were thinking, okay, the political party gave state money for many people. They favored people, their families, and so on, so everything should be public. Well, I was reading that a person who was well known as a writer of these times, she applied for a state aid because she said that her grandson was in a very bad health condition, and she was describing in half a page the diagnosis of the disease. So I told them, it's a lot of private people in these decisions. You cannot open these people to the public. So you should be very delicate in the publication of the documents. Then, just a few words in our countries. We do have very often separate archives on the former state security services documents. So the archives in Bulgaria were a bit later opened than in Germany or in Hungary, but they were opened primarily because of the big public debate, and one of the cases that were underlying this debate was the case of the journalist Christoph, who wanted to read documents in the archive about the murder of the BBC journalist and writer Georgi Markov in 1978 in London, in the Waterloo Bridge, on the Waterloo Bridge, with the poisonous Bulgarian umbrella. He was denied access by the intelligence services and the Ministry of Interior, so we went to the court, we won these two cases, and they also became the ground of the campaign for having a new law. So we got a new law on the archives, and still we have, of course, Christoph got all the documents, and he even almost identified the physical killer. And here it's interesting because the suspected person, it's suspected because the evidence is not enough, is originally an Italian who was made a collaborator by the Bulgarian Communist Services, and who was trained to be a spy and even to kill people. We don't know whether he did that. The profile of the person implies that perhaps this is not possible, but still this was something very interesting, and Christoph wrote a book about that. And the case Anchev in Strasbourg is an interesting case because it's about the same thing. Someone who was disclosed under this law on former state security services, because there is a requirement that people who run for public office or were in public office after the changes are subject to this law, and Mr. Anchev was Minister of Justice. So he complained that his personal data has been illegitimately disclosed in a breach of Article 8 of the European Convention of Human Rights. So the court in Strasbourg balanced Article 10 versus Article 8 and found that in these cases, in these countries, in these regimes, it is legitimate and the public interest to have knowledge on this belongingness overrides the privacy of people. How about courts? There is a lot in courts. We had an interesting case because the Supreme Administrative Court in Bulgaria was very well digitalized since 2000. It published online all the files. So at some point in 2015-16, they made a reform and they started anonymizing all the names of the litigants, even the public bodies, on the account of personal data protection. So 16 reporters started a case against that, and we went to Strasbourg. And what was interesting is that Strasbourg took a survey about court documents, and why I'm linking this to archives, because some of the court documents are very old. They're since 2000, 2001, and so on. And they fall in the archival part of the website. But it did have the same access. So in the end, Strasbourg decided that it will not hear this case because actually the practices of the country members are 99% anonymization, not any really good access to court documents. I think that we have problem in the EU with access to court documents after all that. But it was good for Bulgaria because the Supreme Administrative Court changed its practice to good, to better. It restored part of the publicity. And so I'm finishing here because my time is over, but I would like just to remind the very important issue of the right to be forgotten. Because applied to archives, it could be a very big disaster. Fortunately, sometimes when people are from Caesar's times, it's not possible to exercise such a right. But when it's about 50, 60, 70 years ago, and a lot of things have happened in the world, this could be a problem. And now after the GDPR, which literally recognized the right to be forgotten, there is a wave of requests like that in all countries in the EU, but in Bulgaria as well. So Data Protection Authority, both in Brussels and the national ones, are interpreting this issue. And well, basically in Bulgaria, the case now is that the media should, of course, do all the diligence exercise review under the GDPR, but they have the authority to decide that the public interest still confirms the publicity of the data. Well, there are problems in that. First of all, when would the public information that the killer has been found guilty will be, perhaps if we talk about this legal institute of, well, I'm sorry, I just lost the word, but after a certain period, even if you have a criminal record, you are understood as not guilty. So of course, you should be, this should be balanced, but also there is a whole story in that. Sometimes we have issues where a name of a lawyer suspected of badly behaving was published together with the whole story of a case. So the lawyer is asking for being deleted, what should the media do, and so on and so on. So I'm stopping here.
Thank you very much. Yes, it was just, I was just standing up. Okay. I think we will switch to another area. We have been talking about, mostly, not entirely, about traditional archives, more or less. Papers, not only papers, but traditional archival institutions. But Lise will talk about new types of archives. Can we have the fifth, number 5? Yes, artificial intelligence. And let me call your attention what we all know, that personal data is not just names and numbers and other figures. Anything what you can combine, what you can relate to a living person, including psychological, physiological, and other features. That's all personal data. And if we continue this line, we could reach a false conclusion that every piece of data in the world is personal, because one way or another you can combine them with a living person. Of course, that would be an absurd solution. So we must find the borderline, and the borderlines are much more softer nowadays with the use of AI. And I ask Lise to shortly introduce herself, not to use more time from her time. Yeah.
Great, thank you so much, Ivan. Thank you for the invitation to join the panel, and thank you to all of you for being here today. So my name is Lise Jaillant. I'm an associate professor in digital humanities at Loughborough University in the UK. And I'm a literary scholar by training, so I was trained in a very traditional way. I spent my entire PhD looking at old papers, in archival collections. But increasingly, as you know, those archival collections are becoming hybrid collections, composed of paper and digital records. And of course, access to these collections can be very difficult for many reasons, including, of course, data protection. So in this short talk, I want to give an overview of the issue of access. And I want to say a few words about the role of artificial intelligence to unlock those digital records. But let's take a few examples. I'm going to start with the paper of Ian McEwan, the British writer Ian McEwan. The papers are at the Harry Ransom Center in Austin, in Texas. And basically, this collection was acquired by the University of Texas in 2014. It was processed in 2015. And it's a hybrid collection. So you have paper records, you have electronic files, you have emails as well. But if you look at the finding aid, on the website, well, it still says that the email collection is closed to researchers because what they say, it has not been processed, so it's not available to researchers. Basically, my experience is different, because when I went there in 2017, I was given access to a selection of emails. And I was very privileged because at that time I had a British Academy Rising Star grant, and as part of the project, I was able to invite archivists who were based at the University of Texas. So they knew me a little bit, and so they gave me privileged access to a selection of emails. So that was very lucky. And I had a similar experience with the Carcanet Press collection, which is in Manchester at the John Rylands Library. And again, because I had another grant, an HRC fellowship, I was able to hire an archivist who was based at the John Rylands Library, and she gave me access to a selection of 200 emails. So I was able to do some very nice visualizations, to analyze those emails. But again, I'm talking of a small selection of emails compared to the broader, to the larger collection. So if you're interested in that, I've published an edited collection, and I have a chapter on Carcanet Press in this book. It's open access. So if you just Google archives access and artificial intelligence, you should find it. Otherwise, just go to my website, lisejaillant.com. And really, it's an interdisciplinary edited collection. We have chapters written by archivists, by digital humanists. We have government professionals, computer scientists, so it's very, very diverse. So the edited collection was published in 2022, and shortly after the publication of this edited collection, I traveled to California for a conference. And because I was in California, I went to UCLA to do some research in the Susan Sontag collection, which is at UCLA. And again, they have an email collection as part of this broader hybrid collection. So as most of you know, Susan Sontag was an American writer, director, political activist. She was born in 1933 and she died in 2004. And this collection arrived at UCLA 2 years before her death. So in 2002, and it continued to grow. And at some point, they acquired the hard drives of Susan Sontag. So that's how they got the emails, basically. Sontag was very keen to protect her privacy, and there are many emails in which she denies having a relationship with the photographer Annie Leibovitz. So what happened is that when the hard drives were transferred to UCLA, well, they did forensics work to review the file, and they gave access to the collection to users. And it was a very generous policy. They gave very generous access to this collection. But what happened is that a UCLA graduate student read the entire email collection, so 18,000 emails, and they wrote an article for the Los Angeles Review of Literature with another academic, and they made public that Sontag had a relationship with Annie Leibovitz. And remember, she would not have been happy with that. She was a very private person. So this is an extract from the article that you can find online. So for example, they say, we also know that Leibovitz was a witness to Sontag's will and that Sontag's hard drives contain sensitive documents regarding Leibovitz's surrogate pregnancy. A simple keyword search for Annie on the UCLA laptop is illuminating, whether we are mongering for gossip or just trying to create an accurate portrait of Sontag's digital life. And they also say Sontag was committed to protecting her privacy during her lifetime, especially with regard to her sexuality, and thus it's surprising that she should choose to open her digital life to the public at all. But of course, Sontag did not open her digital life. UCLA made this decision in agreement with the Sontag estate to give access to the emails. But when I visited the UCLA special collections in 2022, well, my experience was very different from that of researchers in 2014. So this is a summary of my work there, so 2 years ago in July 2022. So basically I had access to just a few emails, just 8 sent messages, 10 received messages. So that's a very small selection compared to the entire collection that contains, again, 18,000 emails. And also there's no indication to users that messages have been removed. Again, a very limited selection. Available only in the reading room. So, I'm based in Britain. I had to travel to California to have a look at those emails. Is it better than no access? That's a good question, right? So there are many other examples of email collections that are difficult to access. So for example, I'm just going to give you one final example. This is the email archives of the British poet Wendy Cope at the British Library. It's a huge collection. They have 25,000 individual emails. And there is an interesting article by Callum McKean, who was a digital lead curator, and he said, making sure that this material complies with data protection regulation in the UK before it is released is obviously a considerable task. And of course, this collection is still very difficult to access today. So again, this access issue is not solved. Artificial intelligence can be a good way to make those collections a little bit more accessible. As you know, AI can be used for sensitivity review, to identify sensitive records and to make non-sensitive records more accessible. AI can also be used to automatically create metadata, when metadata is missing or is a bit problematic. And AI can be used to search huge amounts of records, especially when keyword search would not be effective. So I've been leading several externally funded projects, to apply artificial intelligence to archives. So you have a selection of my projects on the screen. So Aura was with Irish partners, Aeolian was with US partners. We've just published a special issue as part of the Aeolian project. So you can have a look at our website, aeolian-network.net. The ICON project was with French researchers, and the Luster project, we're still finishing this one. It's in partnership with the Cabinet Office, and basically what we want to do is to improve the preservation, access, and usability of government archives. So we pay a lot of attention to government records here. It's funded by the Arts and Humanities Research Council in the UK, and our key partner is the Cabinet Office. So we have many government professionals, people who work in knowledge and information management, who are part of this very exciting project. So as I said, AI can be useful to solve data protection issues, to make archives more accessible, but of course humans also have a role to play. And there are many practical things that archivists can do to make archives more accessible. Just let me give some practical suggestions, perhaps. The first suggestion really is to consider giving access perhaps only to trusted users, especially when a collection is fully closed. It might be better to give access perhaps to academics or other professionals, people you can trust because they have this affiliation. And of course, you need to make this selective access transparent. It needs to be very clear who has access and who has not access. Also explore options to give access remotely. It doesn't really make sense to travel to another country to have a look at email collections. And finally, it's really important to encourage discussions between archivists and users, two-way discussions. And it should be obvious, but sometimes we tend to work only in our sectors, only in our fields, and we don't really have those discussions. And I think that's a pity, really. So let me conclude just with further readings for people who are interested. You can have a look at my website, lisejaillant.com, for the links to those open access articles. You don't need to log in or anything. How can we make Born Digital and digitize the archives more accessible? That's an article I published in Archival Science 2 years ago. And the other one was co-authored with a computer scientist, Annalena Caputo. So again, we are talking of AI applied to archives. That's always good to have those collaborations with computer scientists. And again, it's on unlocking digital archives. So thank you so much for listening. I'm happy to answer any questions if you have any. Thank you so much.
Thank you very much, Lise. Thank you to all. And I now open the floor for questions and comments from the audience. You were the first, quite fast. Yes, in the mask, yes. Yes. We have only one.
Thank you. My question is a two-pronged question for the colleague from the EDPS, Ms. Falla. So I was wondering, how does the EDPS decide which documents are of lasting value? What are your criteria? And maybe you could elaborate on that. And also, you were just starting to talk about data minimization from an archivist's point of view, and I would really like to hear about that. So if you could elaborate a little bit, that would be great. Thank you.
Please don't respond now. We collect a few questions. Okay.
Hello, first of all, many thanks for the great presentation and for the great workshop. To all of you, just one comment, I could not find the book online to download for free, so maybe we can settle that later on. I won't run away, for sure. Then I have a question for Ms. Luisa. By the way, I'm Andrzej Szebesta, in Europe. And I would like to ask what would be the safeguards to protect the rights of data subjects, so the rights to access to the information when it comes to special category of data, and when these requests could be denied based on a disproportionate matters on the side of the organization.
Thank you. And the last one, and then you can respond.
Thank you. I'm working with data protection in Latvia. My name is Maris, and maybe the question is for a representative of EDPS. There is two terms in GDPR. One is restrictions in Article 23, and the second is derogations in Article 89 about archives. How you treat this difference, restrictions or derogations, because in human rights law there is a understandable this because it relates to the state. State can derogate from certain treaty articles, but how you treat in one document that applies to the member state, derogations, restrictions, why it is this difference, maybe you can explain it to me. I don't understand it.
Thank you very much. That's the slide I wanted to. Sorry. We have 3 questions. More or less, it was the questions were addressed to Luisa. So please start, Luisa. But other panelists can also have an opinion on the questions.
I will start with the last one because I cannot answer to that, not being a legal expert myself, and I'm looking at Alexander in case he can provide useful input. I go then back to the previous questions. How does EDPS do? As I mentioned, and this is really the reply from on the ground work, not from any advice on data protection matters. But we are working on the basis of retention schedules, and we are continuously, the colleagues in the unit are continuously interacting with services to clarify whether there are legal reasons, whether there are financial administrative reasons that are necessary, that are reasons to keep for a given period of time as administrative retention, and then discussing on which criteria, together with the originating services, which criteria they would consider would warrant the enduring value, discussion, records manager and services, and then discussing with the DPO what kind of safeguards have to be put in place during the administrative retention period, after the administrative retention period, until we reach the 30 years mark, so to speak, and then to address the other question on sensitive data. The discussions that we're having at the moment are precisely in the preparedness phase. So in a way, it's a slight relief on my side. I'm afraid I won't be able to say what we do once we get there. But linking back to what Liz was saying, I think certain safeguards, provided that sensitive information is contained in records that have been selected for long-term preservation, the safeguards may also be a granularity in access, be it on-site with all the limitations that you pointed, and indeed from an access to archives perspective, given access on-site to emails may not be the more logical solution. Also, given access to only selected users may not actually address the fundamental question. But granularity or technical measures that may allow for online access with particular credentials or with particular or a layered access policy could be explored. Having said that, this can only be a general remark, because then the specificities of the data, the context in which they were collected, so the context of the archival holdings will actually have weight on more on one or other solution. And again, I'm speaking about records that were already selected for permanent preservation. So there is already a legal basis for having that information in the record being preserved with the optic of giving access to it.
Thank you. And the last remark that Liz was talking about deceased persons data. And in a strict sense of the word, the deceased persons have no personal data because they are not alive anymore. Of course, it doesn't mean that their personality and their privacy is just cut when they die. And there are different legal measures how to protect the deceased persons' data through another person or in general. But the personality, if we don't talk about data, but we talk about privacy, then, or personality, more broader terms, it doesn't cease to exist with the point of death. So that's a different, it's a broader category than simply data protection regulations which apply to living persons' data. The bell, the persons with the bell is a long tradition in CPDP conferences for those who are not really familiar with this. Last words?
Yep.
Yes.
Perhaps on the issue of the derogations and restrictions. Well, obviously, I completely agree that from point of terminology, there is a kind of shift or development here. But obviously, it is meant that some important other fundamental rights or legal interests are versus data protection. Well, here we have judiciary, we have access to documents, we have freedom of expression. And sometimes you have them combined, because in a decision since a few years ago, the Luxembourg court has decided that, for example, access of journalists to court records given by the court administration falls under the judiciary exemption, the judiciary derogation. But in these cases also you should have a different supervising body. It's very often not the same data protection body. Like for judiciary, it could be a different one. For journalism, it's question mark. But briefly, that's it.
Thank you for all the panelists and all the active participation from the audience. And you can write down the address of the free downloading site.
And we have a QR code here.
And also a QR code if you get closer. Where is the blue link? Yes. Okay. So that's the secret link to have access to the book on access. Okay. Okay. So thank you a lot.